Welcome. My name is Wanda Rochelle, and I am here today live. We are talking about frequently asked questions regarding probate and deeds. And I have a special guest with me today. I have attorney Rhea Johnson. She's no stranger to my channel, so I'm excited to have her here. Welcome again, everyone. If you're here, please go ahead and subscribe and like the page, and prayerfully, this will be educational for everyone, and please share it with everyone that you know. So let's go ahead and get started. Again, welcome, Attorney Johnson. Thank you for taking time out of your busy schedule.
Thank you for having me. Always good to be in your company.
Awesome. So the first question I have is, what is a year's support, and how does that work? And that's a common term that I hear with probate.
Yes. So, year support is a resource that's available to spouses and is also available to minor children.
Mhm.
So, if a spouse passes away and leaves one spouse behind, that spouse can ask through a petition for the court to award a year of support from the resources or the assets that the spouse left behind. So it's basically for a dependent spouse that is dependent on the decedent for, maybe just maintaining the lifestyle that they had. And so the law allows them to maintain that lifestyle for at least a year. And so sometimes that value is one that can be a large sum, it could be a small sum, just depends on the family. But it is definitely a very strong tool, especially for minor children. So
Mhm.
minor children can also take advantage of the year support. What it allows you to do is step ahead of other heirs. So if there are heirs, for example, there may be children, adult children that may be entitled to receive as heirs under an estate. A spouse could step ahead of them and receive assets. A spouse can step in front of them and receive, or step in front of creditors and receive assets. So it really is important when a person is dependent on their spouse for support, but the spouse has left behind so much debt. And so, in order to clear the estate, you have to pay all these debts off. But with the
Mhm.
year support, you may actually be able to have some of those debts be waived and allow for a spouse to be able to actually take the asset or the resources that that spouse left for their support.
Mm. Okay, wow. I didn't know that they could be pushed to the front of the line per se.
Yeah, 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 yeah.
Awesome.
And a lot of times, people do contest your support. So the contest a lot of times comes down to a financial question as to whether or not the spouse really was dependent on the other spouse in terms of what the financial picture looked like. So,
Hmm.
um, and the law is very liberal in this way. It really is geared to allow a spouse that 1 year support. So it would really have to be a very strong objection for a court not to award it.
Hmm.
So in most cases, the spouse or the minor children are successful. I will say that year support can also be one of those situations where when you do have minor children in the family, year support would have to be split between those minor children and the spouse. So depending on the court and depending on how the resources show in terms of distribution, a court might very well take the assets that would normally a spouse might think would come to them and split it between them and the minor children. And so
Hmm.
for that portion, the court may appoint someone to serve as a trustee for the children, and the spouse may still end up having to share with the minor children, where she wouldn't have to share with the adult children. So it's a consideration when people have minor children. A lot of that comes into play with estate planning and how well you set up your estate plan.
And I'm just sitting here thinking that it's so important that we have videos like this, because we know that this is a real world where, let's say, um, husband passes away, wife is in the picture, and there are children that the husband and wife had together, and then there are other children outside the marriage. So I'm thinking that this video is important to know because that other mother may not even know that she has the right to, apply for this year's support to take care of her minor child.
Right, exactly. Yeah, the minor children, they do have the right to year support. So you're speaking about children, minor children that are outside of the marriage.
Yes.
Oh, yeah, yeah,
Yeah.
absolutely, yes.
Right. They wouldn't know.
Yeah, they may not know. So they definitely need to consult counsel anytime anyone is an heir to an estate. I think it's important to consult counsel, and it doesn't always have to be adversarial. A lot of times, people can come together, they can work together. But I think people put up their dukes immediately, and they're like, "I'm on this side, you're on that side," and really,
Yeah.
there's still just one pot. And if we fight over it, sometimes someone loses. When really, um, in most cases, there is some common ground that could be reached. If people would just allow for that, it could make things a lot better.
Absolutely. Let's see. What's the difference between a will in common form and solemn form?
Right. So a will is a will. The will is not necessarily drafted in common or solemn form. It's the petition that gets filed. So you
Hmm.
file a petition for the petition to go forward in common form, or petition to probate a will in solemn form. And so when
Hmm.
you probate a will in solemn form, an executor can put forward a petition and be awarded letters testamentary and have all of the rights that have been granted to them under the will, with almost no limitations unless the limitations are in the will. Whereas with common form, um, the difference is that you don't have to notify all of the heirs. Whereas with the solemn form, you're going to file this petition. You're going to notify everybody that needs to be notified, give them ample time to come forward, make their objections. With the common form, you're filing it and you're bypassing the notice requirement, so that when you do get those letters testamentary awarded, you are limited. You don't have all of the powers that would have been granted to you right away. So, and the main thing is that you can do the things that the will says you can do, but in
Hmm.
reality, it's for a 4-year time period for anyone to come forward and make those objections. So, whereas a person who files a petition under solemn form, once they become the executor and have those letters testamentary, they can begin to move and act under the authority of that executorship
Hmm.
without feeling that they're going to be held liable for actions that they may take as an executor. Because it's still human beings. People take certain actions, and sometimes you believe that you're acting as a fiduciary, you're doing the right thing. You want to be covered. Whereas under the common form, you take certain actions, you may not have any covering, and you can still have people come forward up to 4 years after and make objections. And for anybody who is an heir that's a minor child, you have to wait until they become an adult. And so they become an adult and then they could object. So literally
Hmm.
certain things that you may do may not be protected, and you may have personal liability for certain decisions you make. So for example, trying to transfer property.
Hmm.
If you try to transfer property under a common form, you may find a situation where you have objections that come in within that time period, and you have personal liability for transfers. Most law firms are going to shy away from a person that has letters testamentary under a common form versus solemn form, because they know that title objections can still come even after the transfer, and that title policy may be the person's resort to
Hmm.
try to maintain.
And that was going to be my next question, whether or not the title could be transferred, because I asked this question because I had this situation, and the closing attorney wasn't a probate attorney. And so I asked him, if he was going to be able to transfer a title, and he had to reach out to a probate attorney to decide whether or not, or to get the answers to whether or not he should
Mhm.
transfer the title. So I'm saying that to say, if he had not reached out to the probate attorney and just had just done it, like you said, then there may have been problems in the future.
Yeah, absolutely. And so most closing law firms, the attorneys have a relationship with a title underwriter. So even though we are the service provider, we work with our title underwriters, and sometimes we have multiples. And so one title underwriter may be more conservative than another, and they may allow certain things and let things go depending on the situation. So he may have consulted with his title underwriter in addition to a probate attorney, but ultimately, what we want to do is transfer property, and we want to give total assurance as best we can to the new home buyer that your title is free and clear of any encumbrances or anyone else that may have an interest in this property. We have cleared all of that, and so you can go away, and sell away without having to look back. And
Mhm.
so this is one of those times where the look back provision is there. So if you sell property and it's a common form probate, the people who didn't get notice, because there's no notice requirement. So literally, a person moving forward with a will, the will could be faulty, it could be fraudulent, it may have a person under duress has signed it, a person who was not mentally capable of signing a will. Um, the notary may not have really been there to witness it. So there are a lot of things that can go wrong. And so our probate court really does a tremendous service to validate wills because, of course, fraud is just rampant. And,
Right.
family members get desperate sometimes in certain situations. And so it's important to have them as an oversight body to review these wills and make sure they're good. But the notice piece is the part where no publication or anything, you get letters testamentary, and then people find out later, and that's when they come forward. And a person could be living in a home, somebody could knock on the door and say, hey, this was my grandma's home. What? You know what I mean? So no
Wow.
no closing attorney wants that situation. And so that's the
Mhm.
reason why we're careful to make sure that we're transferring title and we can give a policy to someone that we can stand behind.
Awesome. Awesome. So, what is the process if someone is a creditor and they want to ensure that they're paid from the deceased person's estate? Do they file a petition? What is the process?
So it really just depends on what type of creditor you may be. Everybody's not going to be considered a true creditor or valid creditor. So the probate laws have very specific guidelines for identifying when a person would be considered a creditor.
Hmm.
And so most of the time, if it is a person or a company that the decedent engaged in a contract with, then yes, this is a contract they entered into, a credit card or whatnot. Yes, it would be a creditor. And so for those companies and those entities, they know to file creditor claims with the probate court. And so those claims get filed. And then once the executor or administrator is appointed, they are responsible for acknowledging those claims and either paying them or settling them with those creditors. And sometimes, it may be a conversation about what's in the estate and what resources are available. Sometimes they say this isn't a valid, debt, and show me the contract. So, they're operating as a fiduciary, so they do have to vet creditors to make sure that these are valid. But I think what a lot of people run into is they consider themselves creditors because they paid taxes or they kept up the estate, they cut the grass and different things like that. And you have to be in a very particular relationship to the decedent, or even to the estate, that you would have been a beneficiary under this estate to be able to claim a creditor position. Everybody that contributes, sometimes it's considered a gift. So you have to be, it's a fine line as to when a resource would be considered a gift versus a payment that a person could consider themselves to be a creditor.
Okay, awesome. What is um what is the process when one of the heirs is incarcerated
Oh, okay.
and that
Yeah.
person needs to sign, specifically if we're selling a home? And I have a colleague that's in the middle of this situation right now.
All right. So when you say a person is incarcerated, you mean a person that's on title,
I mean, an heir to an estate.
an heir to an estate. So it depends. So basically, when a person passes away, a legal representative is typically the person that sells the property, the legal representative. So
Mm-hmm.
if you need an heir to sign at closing, it sounds like there's no legal representative, and maybe you all are doing some kind of deed of assent or something like that.
Mm-hmm.
Because once the court appoints a legal representative to serve on behalf of the deceased person, that person can sign an administrator's deed and or an executor's deed at closing. You don't need all the heirs to sign off on that. And I've heard other people tell me that a closing attorney required them to do this and that. But again, that may be a situation where you have a closing attorney that specifically deals in real estate, doesn't do much on the probate side. So they're not as familiar and versed with administrators and executors deeds. But that legal authority that the court gives will either allow for an administrator to sell property or not. And same thing with the executorship. That authority is given by the court. And so
Mm-hmm.
the deed that is signed at closing is that authority that stems from the probate court giving it to that person to act. And so what happens is this person acts on behalf of the estate and sells the property. They sign at closing for the estate. And they're then responsible as the fiduciary for taking the proceeds and putting them into an estate account. And
Mm-hmm.
then from there, they're responsible for paying any debts that the estate has to pay if they weren't paid at closing. And then they're responsible for dividing those assets up between themselves if they're an heir and everybody else. So that's
Mm-hmm.
what an administrator and executor is supposed to do. So a lot of their job and their role is to identify what assets are there, liquidate them, and then bring that money into the estate for the benefit of the heirs. So that, I'm not quite sure, what the situation is on with the heir on that.
Mm-hmm. Mm-hmm. So just listening to you, um, it's good for me as a real estate attorney to ensure that if I have a closing, that I utilize a real estate closing attorney who also knows probate,
I
because
mean,
I'm seeing, yeah,
mhm.
I'm seeing some inconsistencies with what you're saying. Um, yeah.
And I will tell you, if a closing attorney has any feeling, and a lot of times it deals with their underwriter. Underwriters can sometimes put certain requirements on closing attorneys that require them to do things a certain way. So I can't really speak to why they would have done that. But um, if a person is doing a transfer and they have that authority from the probate court, we very carefully review the documents that the probate court provides just to make sure that the authority is there. We
Mm-hmm.
look at the petition to make sure to see who all received the notice. And so if a person is selling property and they have a last will and testament, we look at the will to see if they have the authority to sell the property. And if we see some limitations on that, you can't sell the property for 5 years. If you sell the property, you must sell it to this one person or give this
Right.
person first right of refusal. I mean, we look at those things very carefully to make sure. So we don't just willy-nilly do it just with letters of testamentary, letters of administration. We review everything. But the authority from the court, we take it very seriously. And we utilize administrators and executors deeds and deeds of assent. Like I said, when you have those, that's a different type of situation. And so on occasion, we've had clients that did utilize the deed of assent to make transfers from heirs. And so that's when a person is deciding that they are not going to go through the probate process. And there is a provision in the law that allows people to avoid probate when a person has been long deceased and all of the heirs are known. So when you
Mm-hmm.
can literally get, 10 people to come forward, all heirs, grandchildren, um, you know, um, stepchildren, anybody that was a part of that family tree, they all come together and they sign off on a deed transfer. So yeah, that can happen. So it could be that, it could be that situation. I'm not sure. But definitely administrator's deed and the executor's deed, they can sell property if they have that permission from the court.
Mm-hmm. Now, yesterday I was looking at a deed and it said executor deed. Um, and the person wanted to know whether or not the deed showed that it was joint tenancy with right of survivorship or tenancy in common. So my question is, sh- my question is, does it matter whether it says those? I guess my question is the estate deed. I'm sorry. Does it have to be in one way or the other? Does it have to be joint tenancy with right of survivorship, or can it be tenancy in common? Does that matter?
Yeah,
Is
so tenants in common and a joint tenancy with the right of survivorship, that is a thing, and yes, it's important.
mhm.
But in terms of being an estate deed, an executor's deed, are you saying that you have an executor's deed where someone deeded property to someone else as joint tenants or as tenants in common?
We didn't know if it could be written either way. That I guess that's my question. I
Yeah,
didn't
so
know if
right. So the
mhm,
executor is standing in the shoes of the deceased person. So
mm,
it's just standing in that person's shoes. And if that person wants to transfer property to two people as joint tenants with the right of survivorship, they can do
okay.
that. But I will say this, an executor is operating under the authority of, definitely from the probate court appointing them, but the will. So if the will says that they should give something to someone as joint tenants with the right of survivorship, then that's what they will do. If the will
Okay.
says that they should give it to whoever they want, then of course they can do however they want to. Wills can be drafted that way. But if it
Mhm,
says they should give it to one singular person, then that's what they should do. So they should follow the will to the letter. If it's an administrator doing it, an administrator needs to make sure that they're looking at who the heirs are. And so I have that situation where I have people reach out to me and they'll say, I'm the administrator of an estate and I want to transfer the property to myself. And
mhm,
so in those situations, I let them know, let me look at the petition and see who the heirs are. And I look at the petition and there are like 5 people on there. So I'm like, okay, well, we can't transfer the property to you, right?
right.
Unless all 4 people, the other 4, decide that they're going to renounce their interest in this property. And then this will say, well, no, they can't bring those people forward to renounce. So then it's like, okay, well, we can't transfer the property to you. Now, if you want
Mhm,
us to transfer it to all 5 of you, based on what we see as the heirs to this estate, then we can definitely do that. And so people
mhm,
get stuck because they believe that being an administrator allows them to just do whatever they want. But it is specific. It's specific in terms of what you're supposed to do. But if you have an administrator with multiple heirs, they can transfer the estate to multiple heirs as tenants in common or joint tenants with the right of survivorship, depending on what the heirs want at that point.
mhm. Okay, awesome. Good information. What is the role of a temporary administrator that is appointed by the courts? And are they generally paid for their services?
Well, any administrator can be paid for their services if they requested. Normally, a temporary administrator files a petition and they are doing it for very specific reasons. And sometimes pay is not something that they're looking for. They are ideally trying to protect assets from someone
Mm,
else. And so they come into an estate as a guardian to protect and to
mhm,
bring in the assets. So if assets are um, at risk for some reason, a house maybe is needs to be locked down, needs to be boarded up, we need to change the locks, we need to restrict access to a property. An administrator can do that. So an administrator can come in and protect and to gather. They can notify the bank, hey, I'm the administrator of this estate. I want this account locked so nobody else can access it. Things like that. What they can't do is distribute assets. They can bring in everything, they can secure it, but they can't distribute it. And it is a difficult piece to do because everything that the court gives and grants in terms of authority is only as good as the people that you're exercising this authority against. I mean, sometimes you do have to get the police department involved to execute some of your duties because you may go to a house to lock it down to prevent people from going in, and there may be a problem with that.
Mhm.
You know, people may not want you to access it. You may even have to evict a tenant as a temporary administrator. So these are things that you can do to protect. But once you do all that protection and get everything in, you let the court know this is the inventory. This is what I found. These are the properties. This is the money in the bank. And once you notify the court of what you have, then at that time, you may be able to apply for permanent administration. But you just really are bringing things in and protecting the assets. That's what you're doing.
Mhm. Awesome. So here's a scenario. Mother passed away. There's only one asset, which is the home. The home is facing foreclosure. However, the amount owed on the home is probably more than it's worth. So, in that case, should that person bother with filing probate or probate petition?
So, how many heirs are there?
There are two heirs, and everyone is in agreement.
Everyone is in agreement that one person is going to serve as the administrator.
Yes, and that the house will be sold, and if there were assets, they would be split. However, we don't think there are any assets
Yeah,
because of the
yeah.
amount owed on the home.
And is the house vacant?
No.
Oh, okay. All right. So, this is the thing. It's always real estate, as you know, is an asset, period, whether there's a mortgage on it or not. So it could be that it's underwater right now, and that's only for a
Mhm,
time. If
mhm,
somebody's able to pay the mortgage, then you can maintain, even if you maintain it with a renter in the property. So just because the house is underwater, I would
mhm.
say that's not a reason to not file probate. But
Okay.
if it's a situation where the house is about to be foreclosed and that's the only asset in this estate, it may be that the bank will allow. Sometimes I've seen banks work with administrators. If they understand that you're getting ready to file probate, and once you file probate, you're going to take out a loan or you're going to refinance that property, you're going to do something, they may allow you additional time. I have seen lenders put a foreclosure on hold to give an administrator 6 months to get in position to refinance or bring the mortgage current. Some people
Mhm,
don't want to do that if they, haven't gone through probate. But if everybody is on the same page, I would
mhm,
say, having a house, I would just ask them to maybe look at this situation, especially if somebody's living in it. That sounds like there's some situational stuff going on there. Somebody's living in the house. So the person that's living in the house is not able to maintain the mortgage. That sounds like what the situation is. Am I right?
mhm, mhm.
Okay. So
Correct.
it may be, and if this person is an heir to the property, okay, this person is in the way. Simple as that. So I don't know how far behind the mortgage is, but if there's any chance of catching it up, that person needs to move. Just because it may be that they can put someone else in the property who can pay the mortgage. You can
Mhm,
rent the property out at the very and so what we're looking for is appreciation in value. That's what we're looking for. So right
mhm,
now it might be underwater, but eventually it may not be. So
mhm,
depending on the numbers there and just kind of looking at how far behind they are. And then, in terms of being underwater, how much underwater. And if it's not that significant, it may be worth exploring some creative deals to see if you can find someone else to hold on to the house, um,
mhm,
in a rental capacity. That way they can maintain it in their estate. But
mhm,
if not, if all is lost and but it sounds like someone's living in the house. Someone's living.
mhm,
So um, I think that, as they're living in the house, they really need to see what resources that person has to stay there. It may even be that family can help to bring the house current and then put her on some kind of payment plan. But overall, having a mortgage is an asset, period, because you have a mortgage where some people can't get one right now. I don't know what the interest
mhm.
rate is, but just having one is important. Um,
Right.
and then having a home, yeah, is important. So sometimes foreclosure can be doom and gloom, but you can always turn a real estate situation around with creative ideas. And I would just encourage them to see the glass half full versus glass empty, and really see what can they do. Can they pool some resources to try to maintain the house and see what they can do with the person that's living there? Maybe she can get a roommate, or he could get a roommate, something, um,
Mm-hmm.
to try to maintain the house, because eventually it's not going to be underwater. It's not going to always be that way.
Good. That was good advice. And the questions that I'm giving you are questions that I get from people, via my YouTube page or my probate Facebook page. So this is why, I'm giving you these scenarios.
Yeah.
Um, my next question is, how long does an executor have to distribute any proceeds from the estate? And let me just give you a little backstory. The young lady asked me this question because the house had been sold. The attorney was handling the estate. The attorney was also the executor. And so the young lady felt like her proceeds should have been from the house, should have been given to her sooner. So is there a time frame in the state of Georgia, um, that process? What is
Yes.
that?
So no, not really. But what the court is looking for is whether or not an executor is actively working and pursuing to the best interest of the heirs. So if you have an executor that's not active at all, that's just sitting on assets, um, and the will says they should distribute them, that's one thing. Some wills do give people some discretion, and it allows for them to do things when they see fit or when they think it's best, to do it. But if you have a situation where a person is going through a process of liquidating assets, I have a client right now, similar situation. I mean, you can go through a process of liquidating assets, and bringing in assets for a very long time. Some people are working with the IRS to negotiate debt, and so that's a
Mhm,
big one. So if you're working with a creditor to try to negotiate debt down, it could take several months to get it down, to where you'll have more money for the heirs. So it really just depends on what's in the estate. If it's just one thing in the estate and there's nothing else for that executor to do, but sell a house and distribute it, that may be a problem. And so I have seen a lot of people go back to the court and ask for that person to be removed, or for
mhm,
that person to show an accounting. So show me what you've done, show me what you've brought in, show me the expenses of the estate. If you're paying bills, what are you paying? Like, what are you doing? So for an executor to just sit on an estate and not do anything, that's not what the law is intended to do. However, the law is there for them to expeditiously, but very carefully, go through a process of bringing in assets and then making distributions. And the first people to be paid are creditors. Those are the
mhm,
first ones to get paid. Nobody else can get paid until they're paid or satisfied or settled. So that
mhm.
may have something to do with why this executor is taking so long to distribute to the heirs.
I think a lot of times I hear heirs are frustrated. They feel like they're not getting enough communication from the executor. They feel like, they need to know, not necessarily every step of, an update every day or every week, but I hear that a lot.
Hmm. Yeah.
Yeah.
So, it's a real thing because executors are appointed. So they don't have to answer to people in the way that people want them to. Um,
Mhm.
Especially if the will says that they don't have to do any inventory reports or accounting. That means I get to do what the will says I should do because it's been probated now. So everybody saw the will, they see what it says I'm supposed to do, but I have the authority and the freedom to take these steps, and I don't have to answer to you. I don't. But
Mhm.
I do have to make sure that I do it. So if you
Mhm.
get called before the court, and people do it, they will file motion to have a person be removed, and like I said, a motion to for an accounting. And when that happens, a person has to go before the court and show. But I would say at least a year. I mean, because once you become if you become an executor of a will, no inventory reports or accounting, you don't even have to do the 6-month inventory or the annual returns. You don't have to do any of that. Now, what you may do as an executor is you may still file to close this estate, just so you don't want to have anybody else looking at you for anything. But they
Mhm.
don't have to do inventory and accountings. With administrators, they have to do a 6-month inventory to let everybody know this is what I have found, this is what the estate includes. And then a year from that, they have to do a return to show what they brought in and what they've paid out. So those are the checks and balances on an administrator, that they don't have to answer to each single person. As long as they file their inventory and accounting, that's available for everyone to see. And
Mhm.
so they do have to allow some room, unless they have reason to believe that someone is doing something that is nefarious or illegal. Yeah.
Mm. Good stuff. Thank you everyone for watching. Please make sure that you share the video and subscribe to the page because this is really good information. Let's see. My next question is, when an heir sells their loved one's home and they live in another state,
Mhm.
are they subject to any type of additional fees or taxes?
No. So they're just serving as a representative for the deceased person. If the deceased person lived in this state, okay.
Mhm.
Now, if the deceased person wasn't a resident, then they would have the same circumstance as a person, as the person who is deceased. So the heir takes on the persona and all of the authority and the rights of that deceased person. And so if that deceased person was a Georgia resident and they sold property and they were within that period where they don't pay capital gains tax, then the person who's serving as a personal representative wouldn't pay an out-of-state um, resident, tax. They would just do normal. So
Wow.
the capital gains tax is something that pertains to the person who's selling the property, and would not you qualify for the exemption, the capital gains exemption. And so, like I said, if the deceased person qualifies for that exemption, then they will too. And then you get
Mhm.
into a situation about estate taxes and whether or not, the person is going to have to pay taxes. And so estate tax is paid by the decedent. It's not paid by the person who's receiving. So if there's a tax on the estate, it's going to be taxed on the deceased person's resources, not on the person that's receiving.
Wow.
So that's a
That's
whole different thing.
and that's crazy to me because I've seen where the closing attorney charged them because they said they resided in a different state.
Okay.
Mhm. Yeah.
Yeah, and the thing is, it's so difficult because it's like, I'm answering these questions, and I hope that that's the whole story. But I definitely like to give my colleagues the benefit of the doubt and hope that there was something else to it. But
Yeah.
no, if the person who is selling the property is serving as a representative, a legal representative of the estate of the deceased person,
Mhm.
they take that on. They don't have a penalty because they happen to be out of state,
Mhm.
selling their mother's home who still lives here in Georgia.
Mhm. Good information. I'm gonna have to go back and look at some of my closing statements. Oh, let's see. All right. Next question is, when someone comes to you to establish a trust, what are some of the basic things, Rhea, that they need at the consultation, at the intake appointment? What are some of the questions that you ask? And I'm asking this because I want to see more people establish a trust, but I know they don't know what that process looks like.
Yeah. I think that, the biggest thing with a trust is just, it's not that different from when you do a last will and testament. The document itself is robust. It has a lot of detail in it, a lot of tax planning, generation planning, those types of things. And so a person who has a clear head and knows how they want their property to be distributed, in death and then over the long term is really important. But a trust is so different, or most different from a will, because you really do have to trust the person that's serving. And so what that means is this person is serving or these people are serving with very little oversight, because these trusts are not filed like a will would be filed. All the
Right.
notice requirements get stripped away. So having a person to serve in a trustee capacity is the biggest decision that people can make when they decide whether or not they're going to do a trust. And so what I find is that people come forward, they have great ideas about a trust, and they want the freedom of a trust, they want the sophistication of a trust. But the part that really breaks down for people is they know what the assets are that they have. They know who their children are. They kind of know who they can trust, with the children, and who's going to do what. People have concerns about, my child's wife or spouse or somebody that's in their ear. But the part that they really, really, really get stuck on is, who do you appoint as your trustee? If not this person, then who? And I think 3 to 4 people. You need about 3 to 4 people.
Hmm.
And these people can't all be like you, the same age as you, in the same situation. You really do have to search yourself. And sometimes it may be a professional in your life that you
Hmm.
developed a relationship with, that you trust. It may not always be the people that you think. But I think that's the hardest part of developing the trust. But clearly knowing what assets you have, which assets you want to put into the trust. So the two things, trustee and the funding, because trust are only they're good, okay, but they don't really come to life until they actually have something in them. And
Hmm.
so a lot of times people will create trust and they take forever and they don't actually fund the trust. And so when they leave the attorney's office, the funding piece is their responsibility. So that means if they have a house that they want to deed over to themselves as trustee, if they have other property, bank accounts and things, insurance policies that they want to put into the trust, these are the specific steps and things that they have to do in order to add property into the trust. So just contemplating that piece, having a document is good, but for it to really serve and have the highest best use, you do need to fund it. And so that's the part that I think people just they don't think about those two things.
Hmm. Okay. Awesome. Awesome. All right. So now we are going to talk about deeds. And I selected this topic because it is a hot topic. Everybody has a question about the deed with the house. And someone asked Ria, what is a judge's deed?
Well, a judge's deed is a deed where a judge transfers property. The judge does a declaration just based on the judge's order. And
Hmm.
so recently, the legislator has tried to put some safeguards around the language that they want courts to use as they make these transfers. It's still somewhat of a gray area. So you can have a deed from a judge in a divorce case that may look a certain way, and they don't always look like a deed. It just may be an order, and in the order it says this person shall receive the rights, interest, and exclusive possession of this property. The thing that most lawyers and closing attorneys and real estate lawyers are looking for is the legal description. And that's the thing that's missing from a lot of judges' deeds. And so if you have a true judge deed, I think that is what the component would be, a declaration of interest to one or more parties where the legal description is clearly defined. So a judge can do it. A judge can convey property. And so if you have a real estate litigation case and the question is who should get ownership, a court can, through an order, um, basically create a deed by their order.
Hmm.
So
Okay.
that's basically what that would be.
Awesome. How does someone obtain a copy of their deed?
All right. So these are all public record. They
Mhm.
are on the Superior Court real estate record database. So people can easily go to their local court and they can go into the real estate room. There is a real estate room at every
Mhm.
courthouse. You can
Right.
go there, and some courts have computers where you can go and sit down and do your work. Title examiners utilize the real estate record room. They go there, they do title research. That's how they pull deeds. A regular person can go in and pull their own deed just like that. Um,
Mhm.
Attorneys do have access to the real estate records because we have access. And so we can pull most deeds. Title examiners can pull deeds that we can't see because even on the electronic record, it may be that the deed is just too old for us to see it. And so someone actually does have to have boots on the ground and go to a courthouse.
Mm-hmm.
But there are companies, like I get people that call our office and they'll say, I got something in the mail and they said, do they, should I pay for this? And so no, as soon as people buy homes, people get this letter in the mail, and what they know is that the law firm may or may not give it to you at closing because they're doing a deed recording. So we
Mm-hmm.
have to actually record the deed, and in some counties it takes a couple of days. Other counties can get behind. We've had counties that had water outages or flooding, and we had, Fulton County was down, because of a cyber attack. I mean, so things do happen, and so when that happens, it takes longer for us to get those deeds recorded. So in the interim, you have these companies that reach out to people and say, "Hey, I know you just bought a house. You want me to send you your deed? I can send it to you for $69." But the
Right.
law firm that you're closing with is going to send you your original deed, and they're going to send you a copy of the electronic recording. So it's going to come to you. But if you've lost your deed and you just want to pay somebody to help you find it, I would suggest reaching out to, to the not probate, but the real estate record room, and going there and doing, that's going to be the cheapest thing to do. It's just to go there and have them to do it. And most real estate lawyers can pull your deed as well.
Thank you for that. And the biggest thing I wanted to point out was those, and I guess we can't call them scammers because it's a legit business,
Hmm.
um, that will send them a mail letter asking for $100 when they can go get it from the deed office for 20. So yeah.
Right, right,
Mhm.
exactly, exactly.
All right, so let's talk about scammers that are attempting to sell homes and land that they do not own. How can someone protect themselves from these type of deed fraud schemes?
Yeah. I mean, I really don't have a really, really, really good answer for you on this, Wanda, because this is a problem. It's a problem, and that's why so many people are getting away with it. Um,
Mhm,
we do have something that we have started doing for some of our clients. It's a little bit of a sophisticated filing that we can do. And basically, what it does is it allows anybody who is trying to sell the property to make sure that they contact the filer of this document, this notice that we put on the record. And so it has to be done by an attorney. It's not something that a layperson can just go and file, but there's a
mhm,
certain notice that we can put out there on the record. And this notice doesn't necessarily preclude someone from filing something, but they won't be able to advance it with a sale of your property until this notice is addressed. And so it's
mhm,
a notice that's out there, and any law firm that is handling a closing for a bona fide purchaser, they will see it and they'll reach out to the law firm. And that's when we would find out if this is our client or if this is an imposter. But
mhm,
definitely people do quit claim deeds all the time. I hear that some courts are starting to crack down on that though, and they're telling people that they can't file quit claim deeds without the assistance of an attorney. But we see that a lot where people have filed quit claim deeds, and these quit claim deeds are faulty. Sometimes they're fraudulent, and they really do create like a cloud on title. And it's not until somebody gets ready to sell the property that we find these quit claim deeds, and then somebody has to figure out if they can fix it. If they can't fix it, and sometimes we just can't close.
mhm.
Mhm.
Wow, wow. What is the difference? I have just two more questions. What is the difference between a title and a deed?
Okay. So title is the deed. Well, let me just say this: title and deed. They're just really just two different things, but it's not necessarily, they're related, but they're not opposite, if you know what I mean. So the
Mhm,
deed is the conveyance document. It's the document where the person received their interest, or a document where somebody conveyed their interest. That's what the deed is. It's a conveyance document. Title is you can say title is the history of the file in a way. Um, and so chain of title is something that we look at to determine whether or not we can advance title to a new person and whether or not we can issue a policy. And so when we look at title, we're looking at who had the property first, second, and third. We're also looking at encumbrances against the deed. So that's more of a it's more of a global aspect about the interest that the person has and whether or not their interest is free and clear. So when you talk about title, the question is always, is the title clear? And so what that means is, do we have a clean bill of health? Yes, I'm a person, I'm standing here, but do I have a clean bill of health? Yes, you have a deed, but is your deed encumbered? Is your deed cloudy because someone else has a deed that looks just like yours and theirs was filed similar in time? Or the deed is, somehow defective because maybe someone notarized it, but they forgot to stamp it? you
Mm-hmm.
know so those are things like you can have a deed, a conveyance document, but it can be defective. Your title
Mm-hmm.
is more of a question of like a global question of you taking everything together. The chain of title, is there a break in the chain? And so breaks in the chain of title would be, and I've seen this before where you have like families where grandma just said, I'm going to give it to Jimmy. And then she gave it to Jimmy. And then 2 years later, maybe Jimmy died and she decided, now Jimmy's dead, I'm going to give it to Susie. And so you
Mm-hmm.
have this property where you got these two deeds on record where grandma gave it to Jimmy, then she gave it to Susie. But once she gave it to Jimmy, it stayed with Jimmy. And even though Jimmy died, now Jimmy has children. So whereas Susie is the ones getting ready to sell it, or Susie's children are selling this property, and they say, well, no, my mom has this interest because grandma gave it to her, but there was a break in that chain. And
Mm-hmm.
you have a deed, but the deed is invalid. So title is the full perspective of whether or
Mm-hmm.
not that deed is a valid deed. That's the question.
And I like, again, educating people because you and I both are in real estate. So these are terms that are common to us. But even like how you said the word cloud, an example of a cloud would be if somebody owes taxes and the IRS is, so is a lien an example of a cloud? What are examples of cloud on a title?
Yeah, so when I think of a cloud, I don't necessarily think of liens and judgments. I think about encumbrances, and those are like debts that have to be paid, like child support liens, taxes, um, any kind of lien could just be a judgment because you had a lawsuit that got filed against you and then they levied against your house. So
Mm-hmm.
these are encumbrances that are directly filed against you. Clouds are breaks in the chain of title, or you have a situation where there was an error in a deed. And even though it might just be, you know, somebody just made a clerical error, we need to go back to the law firm or the lawyer that drafted it. And a lot of times, if we can go back to the law firm that drafted it or the lawyer that drafted it, they can file something with the court called a scrivener's affidavit to just say they made a mistake. And it happens. I mean, all law firms have this happen where, they filed a deed and it's somehow defective. They can do a scrivener's errors affidavit to say, hey, I made a mistake on this one. This should have been Tammy with a Y, but it was Tammy with an IE.
Mm-hmm.
Can't find that lawyer. Okay, this lawyer is deceased. The law firm is no longer in business, or it was a quit claim deed. It's not a situation where you can just go to a professional and say, hey, can you make a correction? Then you have a deed out here on the record and the deed is just wrong. And sometimes you have to litigate issues to try to get beyond it. Some title underwriters will allow you to still close if it's very, very, very old.
Okay.
They may decide that it's so old, they'll take the risk, or the amount that the property is selling for the title policy is so low, we'll take the risk. It can happen that way. But a lot of times, clouds on title deal with people having heirs or other interests in this property that are somehow unknown or have not been fully addressed. So there's somebody who has an interest in this property and it's not fully clear that we can move forward with it without addressing it. So there are a lot of times issues with the way that the deeds are recorded. That's really where the cloud on title comes in.
Hmm. Okay. Awesome. Great information. So there's a new type of deed in Georgia, beneficiary deed. What
Hmm.
does this new deed do for us?
Well, it's so interesting that you asked this question because I'm like, it really literally just became law July 1st and it's July
Mm-hmm.
24th. So you were right on the cusp, right cutting edge of everything real estate. So I
Yes.
applaud you for that.
Yes.
So yeah, it's a transfer on death deed. It is amazing what it can do. And so
Mm-hmm.
I'm really interested to see how many people are going to come forward. I think it's going to create a whole new um, even though it's a great estate planning tool for people. I
Mm-hmm.
think it's going to create some issues though, because it's one of those things that you just open up a can of worms. But to make it clear, and that's me just thinking about all the things that could happen with it.
Right.
Transfer is a person can literally choose the beneficiaries, one or several, that they want to take ownership of their real estate upon their death. The deed
Mm-hmm.
will not transfer until the person is deceased. So it operates much like the joint tenancy with the right of survivorship. The difference with it is that with the joint tenancy, you actually put persons on title with you right now in life. So they become a
Mm-hmm.
joint tenant with you now, and then when you pass, they survive you. But the transfer on death is you don't have to put your children on with you in life, because people are worried about that because they're thinking my child might have a debt that they have to pay. They may have some IRS debt. I don't want them on my property. So you literally can set up a deed where you transfer the interest and it only takes effect upon your death. And so there's some stipulations about how it happens, and some technicalities with it. But if it's done right, and the person follows through with those technicalities once the person is deceased, they won't have to go through the probate process. So it's a really good tool to avoid probate. It also, funny enough, is you can do a transfer on death even if you've done a last will and testament. Okay, you can do a transfer on death, and it's not going to be voidable by the will. So even though there may be a conflict with what your
Wow.
will says and what your transfer on death deed says, the transfer on death is going to survive that. So it's really interesting. I'm not sure what the catalyst for it was in terms of why the legislators did it. It was a surprise to me. But
Mm-hmm.
it's definitely here. It's here, and people can use it for estate planning.
So do you know if it can be transferred to more than one beneficiary, or is it limited to one
No,
person?
you can do more than one beneficiary.
Okay.
And you can say how you want them to hold it. You can say if you want them to hold it as tenants in common, or if you want them to hold it as joint tenants with the right of survivorship. Mhm.
Mm.
Yeah.
Awesome. Well, this has been great. Um, I do want to make sure that everyone knows that, and I don't think we said this at the beginning, that you practice in the state of Georgia. So just kind of tell everyone about your firm so that
Yes.
people know how to reach out to you.
Thank you. So we are a minority-owned firm. My husband and I are the sole practitioners of the firm, and our staff. We work really hard to try to give people really good service in real estate, estate planning, small business counseling. And so at the end of the day, we are located in Georgia. We have clients all over the state. We do facilitate real estate closings in the metro area and beyond. So if you do, need our services, our main office is in Fayetteville. But if you want to close somewhere else, we can send a notary and an attorney to your location to help facilitate certain parts of the closing. So we try to be accessible and relatable, so that all of our clients feel comfortable at the closing table, or customers feel comfortable asking us questions. Because I know a lot of people come to the closing and they just like, okay, they told me to sign here, sign here, sign here, and
Mhm.
they don't feel like they really had the customer service. And so we definitely try to do that, because we understand that home ownership and just buying real estate in general is really one of the biggest and most important purchases that you ever make. So we want to be partners in that process. So you can reach us at www.rsjohnsonlegal.com. That's www.rsjohnsonlegal.com. And our office number is 404-862-6922.
Awesome. Well, thank you so much. Is it anything else you want to add about any topic regarding probate,
Mhm.
estate planning, anything that comes to mind?
Yes, I'll say this. Dependent, I did a little chat in my car the other day, just came to me, and I was like, this is so important. People that are dependent spouses or children having, people that have minor children really need to consider estate plans, because I think what happens is people find themselves in a really tough situation when people die unexpectedly. And if you know that you're dependent on your spouse, or you're dependent, or you have minor children, and a lot of times if everything is going well, nobody really, um, nobody thinks about it. But if you have small children and you don't have a last will and testament, that last will and testament is critical for small children, because in it, that's where you appoint the guardian for your child and you appoint the trustee. So you have families where a husband is deceased and leaving a wife behind without a last will and testament. They have to go before the court as an administrator. And when they go before the court as an administrator, they don't have any trustee powers. So luckily, the parent is still left and can be the guardian of the child, right?
Mhm.
Because they are the natural parent. But when it comes down to assets, when assets come into that estate, they actually have to go some to the wife and then some to the children. And the portion that goes to the children is held up until they become 18 years old. So you cannot take the assets from one house that you want to move out of and get a fresh start and buy a new house,
Mhm.
because the proceeds are going to be split between the wife and the children, and the children's amount is separate. So that could be 2/3 of the proceeds. And so even though you're the mom, you thinking I'm the best parent, or I'm the father, I'm the best person to manage my child's funds. I'm not going to do anything to harm them. I'm going to do everything in their best interest. The court says no. And so they'll have to appoint a separate trustee, a court appointed person, to just hold that money in an account. And
Wow.
so having a last will and testament when you have children that are under the age of 18, I mean, just by a year, it makes such a difference, to have that. And then, like I said, I see a lot of people getting older and they have spouses, and their spouses, they didn't get the power of attorney, they didn't get the last will and testament, they didn't get anything, and now they're on the borderline, and they don't even know if they can get to the office with them. Like, it's like, you don't want to wait until a person doesn't have the capacity to give you power of attorney, or doesn't have the capacity to give you a last will and testament. So if you know you have a dependent situation in your household, talk to your significant other about an estate plan. If they care enough about you to take care of you now, why wouldn't they want to take care of you, if something happened to them? So I see a lot of people in that situation. And so I just urge people to come forward and let us, do an estate plan for them that will, keep them on a good path once that person is deceased.
Yes, we need to have our affairs in order. So, yeah, I will say this: a lot of people watch these videos and they set their goals to do it. So
Mm-hmm.
people are doing better. It's good to
Yes,
know.
yes, yes, yes. You're reaching a lot
Mhm.
of people, and we definitely appreciate what you're doing. So thank you for that.
Yes. So thank you again for joining me. My name is Wanda Rochelle, and I am a licensed realtor. And thank you again, Attorney Johnson, for coming on my page. And we'll see everyone on the next video.
All right. Take care.